Good evening, everyone. Or good middle of the night if you're in the UK. Yes, I can see you, little Miss Madhead. I can see you. Hello, Grey Wolf Paranormal from Canada. So it was either do a live stream or go out for a walk because I can't sleep. It's like nearly 2 a.m., but I just can't sleep. So the dogs are asleep. So thought I'd come and do a live stream. I know there's about a gazillion lives going on at the moment, mainly about Sebastian Rogers, but it's okay. I'll keep this one reasonably brief so people can catch it on the replay. We've got a few people coming in, a handful of people. All right. Now, because Judge Francis Seagull likes to conduct injustice in the dark, we only have the word of people who were actually in the courtroom as to what happened at today's hearing. Yesterday's hearing for me, but today's hearing for most of you. So there was a hearing at 9 a.m. Eastern. And the big takeaway that came out of it was that the trial of Richard Allen's trial, which was due to start next week, has now been delayed until mid-October. And it's now going to take the slot that was put in place when the interim attorneys were on the case. And then when Richard Allen's defence evoked the speedy trial, then the October date was vacated in favour of the May date. So we're back to October 15th, 14th or 15th, and the trial will run for 1 month instead of the 2 weeks that she'd allocated it. So, because we've only got the words of people who were actually there to go off, then I'm going to assume that the things that people are putting out are at least broadly accurate. All right, so what you're seeing on your screen is some notes that someone who allegedly was there took. So I'm going to read them because it's as good as we're going to get. Now, this is someone on Reddit, on one of the Delphi subreddits called XTTX. So I've only got their word that this is in any way accurate. So that's my disclaimer. All right. Now, some of the things that are in here are being reported by journalists who were in the courtroom. So we know some of it's accurate, but I thought it was interesting. And I've no reason to doubt that what this person is saying is a complete lie. So I'm going to read it anyway. It's only 4 pages. And it maybe fills in some of the gaps as to, well, what on earth happened? What on earth happened? All right. So notes from before hearing began. Leesenby was standing right inside the entrance after the metal detectors, watching people come in and talking with another individual. So that's Tobe Leesenby. Click walked out of the courtroom as I walked in and looked very nervous. So that's Todd Click, clearly. Gull seemed more personable, chatting with and joking with others in the courtroom. So she was personable, in a good mood and chatty. I didn't know it was Halloween, but anyway. Gull seemed to be talking with other court staff about plans for jury selection. She was not in robe at this time, sassy, as she puts out papers on both state and defence tables. Sassy Fran. All right. Olga and Rosie enter. Rosie picks up Russ McQuaid's mess and is now owed lunch from Mr. McQuaid. I don't know who's Russ McQuaid. I've no idea who Russ McQuaid is. No idea. Rosie was pushing one or two rolling file carts. Baldwin enters shortly after with another one or two rolling file carts. Okay, so clearly coming prepared with probably everything that they can. Defence and Richard Allen's family entered from the back of the courtroom, like at the hearing in March. Richard Allen's mother and wife were there. So they're always there. McClelland and Dina enter from doors at the front of the courtroom. McClelland has one box of files and Dina has a binder. Dina and Rosie have an extended friendly exchange behind the defence table. So for those not keeping up, Rosie and Baldwin, of course, are Richard Allen's attorneys. They brought on Olga to help with them. So I think she's a friend of Baldwin's. And then McClelland has the help of Dina. So Dina and Olga are quite new to the teams. So Dina and Rosie have an extended friendly exchange. Courtroom got quiet when Richard Allen entered the courtroom. He was not accompanied by Cert today. What's Cert? I don't know what Cert is, but anyway, he wasn't accompanied by them today. I think only Allen County correctional officers or sheriff deputies. So if you saw what came out yesterday, Richard Allen had been moved from Wabash Valley State Prison to Allen County Jail, which of course is Francis's home county. And Allen County Jail was one of the jails that the interim attorneys, Labratto and Scremin, wanted Richard Allen to be moved to. And Francis said no, just like she said no on previous times when the rightful defence, Rosie and Baldwin, on previous occasions, had asked for Richard Allen to be moved, as was then Westville Correctional, to Cass County Jail. Rosie arranged for Richard Allen to be housed at Cass County Jail because that's close to where he works. And she's always said no. Well, turns up yesterday, Richard Allen is moved to Allen County Jail. Now, the question is whether this is going to be a permanent move. Now, the trial isn't on next week. I was assuming, and we've got a new mugshot. I'm sure that you'll have seen this, but seeing as I've got it, 1 second, just hop it in here. That's his new mugshot. Looks like he's aged 10 years, doesn't it? Looks like he's aged 10 years in the last 18 months. It looks like a different person. But anyway, so I assumed that she's moved him to Allen County Jail ahead of the trial, because travelling from Wabash to court and then back, like every day throughout the course of the trial, that's incredibly taxing on, resources. So I assumed that he's been transferred to Allen County Jail ahead of the trial. So in time for the hearing today, well, yesterday, my time, and then the trial next week. So it's going to be interesting to see what happens to him now. Is he going to get transferred back to Wabash, or is he just going to stay at Allen County Jail? Now, personally, I'd much prefer him to be in a county jail. That's the rightful housing for someone who's denied bond, who is, pre-trial. Why ever he was housed at a state prison at all, well, we can only speculate. And for those truly not keeping up, he couldn't stay in Carroll County Jail, like way back, before Francis even took over the case. Couldn't stay in Carroll County Jail because they didn't feel it secure enough. So instead of transferring him to another county jail, they transferred him to Westville State Prison. And we all know what happened there. He was looked after by these Odinist guards and had a terrible time. Anyhow, back to these notes. All right. So, courtroom got quiet when Richard Allen entered the courtroom. So, Allen County Corrections officers or sheriff's deputies seemed less alert today than in March, but did smile a couple of times with his attorneys. Baldwin and Auger each patted him on the back. Okay. Preliminary matters. Gull acted like she didn't know who attorney Auger was or why she was there. Look, if it wasn't the middle of the night and I wasn't feeling a little bit short-tempered, because I am, right, I'd go and find the acceptance of Auger. I don't know what the word is. When she said, yeah, okay, I'll pay this woman. So she's now claiming she doesn't know who Auger is. All right, whatever. Rosie reminded her that she'd filed an appearance a week or so ago. But Auger's been working on the case for a little while now. All right. And in correspondence, in all the correspondence in recent weeks, Auger has been on the mailing list. So Francis has been sending all like the court correspondence to Auger. So I don't know. Maybe she's been on the loopy juice or something. All right. Gull said she had ruled on that and they will receive it soon. Good. Gull says she ordered on that motion on 5-2 and is not sure why it was not entered by the Carroll County clerk. Or blame the court clerk. Cool. But she had her staff enter it this morning. All right, whatever. Whatever that's, I don't know whether that's to do with Auger or something else. Rosie asked for clarification regarding that order before proceeding. Auger may be making arguments there. Oh, yeah, so it was relating to Auger. I'm telling you, she agreed. I'm telling you, she agreed to paying Auger. Out of touch is one way to put it. Yeah, I know they filed a motion to get her removed again, but she's just going to deny it without a hearing. That's all that's going to happen. Community Emergency Response Team. Ah, okay. So that's who CERT is. All right. Okay. So Rosie asked for clarification regarding that order before proceeding. Olga may be making arguments today, but they don't want her to cross any boundaries with her representation since they haven't seen Gould's order. Okay. Scheduling issues for jury trial. Rosie doesn't think they can practically complete trial in that time frame. So, if you remember what Francis thinks they could do. Now, bearing in mind, let's do a nice comparison here. Bearing in mind the Karen Reid trial, which is currently ongoing, whose defense is, putting on a defense of third-party culpability. That trial is scheduled to last 6 or 7 weeks. Now, they did a whole week of jury selection, so the trial's going to last 6 to 7 weeks, right? And if it goes longer, it goes longer. In 2020, I was a jury member on a murder trial here in the UK. And that was originally scheduled for 2 weeks, but it ended up running for 3 weeks. So they told us at the beginning that, you're going to be here for 2 weeks. However, we don't want you to get selected and then not be able to stay for longer, work commitments, family commitments, etc., if it runs over. So they warned us that it might run over, and it did. It did an extra week because, things happen. There's certain objections that take time. One time we had to get sent home before lunchtime because none of the water was working. So we couldn't flush toilets or anything like that. They had to send us home. There's unavoidable things that happen. So, and that was nowhere near a complex case. Yes, it was murder, but the defense only put on like a couple of witnesses, and then the defendants wanted to testify. So the defense had a day. The defense took a day. The prosecution took the rest of the time. Anyhow, Karen Reid scheduled for at least 6 weeks. And if it runs into 7 or 8 weeks, well, the jury have been informed, right? So it's going to be a long trial. But Francis said that, well, jury selection is going to start May 13th through May 16th. They're going to do opening statements on the 16th once the jury's been seated. And then it's going to run for 2 weeks. So overall, you're going to get 3 weeks. But jury selection, she's allocated 3 days to it. And she can't understand why the attorneys have turned around and said that they don't think they're going to be able to do the trial in the time allocated. Okay, so that's where we're at. So Rosie doesn't think they can practically complete the trial in that time frame, even after talking with McClelland about it. Gould is upset because the first time this was brought to her attention was in the 30th of April filing. Now, to be fair to Francis, to be fair, I'm going to be fair to Francis here. None of the attorneys had, not in documentation anyway. None of them have questioned the time frame that she'd allocated. So she is right that it was very late before they started to talk about this. Now, whether it's been discussed in private, just between the attorneys and Gull, like off the record, who knows? But certainly in what we can see, in the documents, in the filings, it is only in the last couple of weeks that they've started to rumble about this, rumble and grumble, that they don't think they're going to be able to do it in this time frame. So, okay. Rosie argues that nothing has been streamlined and there hasn't been many pre-trial conferences or conversations about the volume of evidence of witnesses. McClellan says he did his best to streamline witnesses. McClellan says many are chain of custody issues, and he is trying to work with defence on stipulations. Okay. Rosie says we are at the state's mercy. Defence wants 15 days to present their case. And, the defence doesn't have to put on a case. The defence doesn't have to say anything. And I'm kind of assuming that Gull, in her naivety, because she's not read anything, like she's not read the Franks memo, she clearly hasn't read anything about the defence's case. She hasn't. She can prove me wrong if she wants to try. But if they want to put on a defense, then they should be allowed to. They should be allowed to put their case forward as, just as the prosecution does. It's up to them. They don't have to, because they don't have the burden of proof. They don't have to prove that Richard Allen is innocent. It's the prosecution who's bringing the case. They've got the burden of proof to prove Richard Allen's guilt beyond a reasonable doubt in front of a jury of his peers. We all know this, right? But the defence, because they're proposing a third-party culpability defence, then they need the time to be able to do that. Just like, it's the perfect comparison is Karen Reid. Because her defence, very rigorous, completely impressed by what I've seen so far in the Karen Reid trial, but they're putting her case forward for third-party culpability. So they need as long as the prosecution. Right? They need the length of time to be able to cross-examine the state's witnesses, but also to put on their own witnesses. And the judge in that case, Judge Canoni, she's annoying, but she's, I want to say she's a tad biased towards the prosecution by the looks of things, but she's being fair, right? She's not put a time limit on it. I've never known a trial to have a time limit on it. And now, listen, I'm not saying that it doesn't happen, but yeah, she just said no. She said, I've told you what, I've had murder cases before that have been tried in this time, and I've had death penalty cases that have been tried in this time. 2 weeks. 2 weeks is fine anyway. Gull argues that due to jury rule 4, she cannot extend the dates of trial. Gull says juror summons were mailed out on 4/19, and defence did not request more time for trial until their 4:30 filing. Rosie says the court never inquired with parties and that it violates Richard Allen's Sixth Amendment right. Yeah, but she did put the dates down. The dates have been written. We've known the dates. So I'm still going to side with Gull here. First time for anything. That she put the dates out and none of them, neither the prosecution nor defence, questioned those dates. So I get what she's saying, that they should have questioned it sooner. So Gull says, I cannot under jury rule 4. So I was curious. So I went and looked up Indiana jury rules. Indiana court rules, Indiana jury rules. Rule 4. Here we go. So this is fresh off the press. It was amended on April the 3rd, 2024. So Rule 4 is in relation to notice of selection for jury pool and summons for jury service. No later than 7 days after the date of the drawing of names from the jury pool, the jury administrator shall mail to each person whose name is drawn a juror qualification form and notice of the period during which any service may perform. So I'm assuming that's what she's talking about, that they've been told the trial date, right? So she can't go against that now. But why wouldn't you just say to the jury, once they all turn up, you know, for selection, that the trial may go on longer than anticipated? Exactly like they did when I was on the jury. Now, different country, obviously, but we have very similar legal systems. Like the United States have drawn on the UK system. We're very similar. There's things that we maybe call different things, like different names for things, but the system's the same. So for us, if you knew that you couldn't stay for longer than 2 weeks due to work or family or health or whatever, let them know, and then they won't select you. So we had like these questionnaires to fill in, and long questionnaires to fill in, and that was one of the questions. And then when we were selected, before we were sworn in, the judge asked us again, are you sure? Please state no. If it's going to be a problem to stay longer than 2 weeks. We're anticipating the trial lasts 2 weeks, but it could be longer. And it absolutely was. It was a whole week longer. It was a whole 50% longer than they anticipated. So Judge Gull seems to like rules when she can apply them. But then she just ignores rules when she doesn't like them. So I don't see anything in this Rule 4 that says that once they've been told, like the notice period, once they've been told, they can't then be told that they may have to stay longer. And if they can't stay longer, let them know, and then they won't get selected. Exactly. She can just break the rules. She's good at that. Exactly. So the judges of the courts of record in the county shall select by local rule one of the following procedures. So that's just about the procedures. So a judge may authorize the jury administrator, blah, 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 blah. Right, so there's nothing in this that says that they can't be warned that they anticipate the trial to last this long, but it could last longer. And they're not going to stop a trial in the middle, are they? I mean, that's just crazy talk. Anyhow, she's relying on Rule 4. Rosie suggested that they be able to ask jurors if they would be willing to potentially stay longer, if needed, during jury selection. Exactly. You can just say, wait, listen, we know in the documentation you were sent that we said that the trial would end on this date. However, we are anticipating it could possibly go longer. Will that be a problem? And for anybody who it is a problem for, they don't get selected. I mean, they have a big pool to work with. McClellan says he cannot predict how long witnesses will take, and they may need to throw in more witnesses if there aren't any stipulations. So he's kind of agreeing with Rosie that, look, we can't say how long the witnesses are going to take. It's done when it's done. Rosie, this direct quote, "You're not hearing what the state is saying." Rosie argues that Gull is inviting the state to call as many witnesses and extend their case. So the defence only has a limited time, if any, to present their case. So McClellan's saying, look, I'll try to be quick, but we can't predict how long witnesses are going to take, or even how many witnesses we're going to need to call. So, you know, if our case goes on for 2 weeks, then we're going to run out of time. It's not rocket science, this, is it? Gull. Now, I feel that there's something missed out here. Now, obviously, this is just someone's notes that they took while they're in the courtroom. So I feel that there's something missing here because they move on to another subject. Gull, when I send emails, they end up in pleadings, and that's not how I like to do business, because it has been reported that she said she's not going to email the defense anymore because her emails end up in pleadings. Gull brought up already having lodging reserved. Oh, so that will be for the jurors, because the jurors are going to be sequestered. Exactly. Gull is never going to allow this to be a fair trial. Yeah, what if the toilet breaks and they have to extend the... I mean, look, in the Karen Reid trial, you know, they've started late nearly every day because of traffic. You know, there's just unavoidable things that happen, especially when you've got, you know, the amount of people who have to be there. If one person is, you know, unavailable, is caught in traffic, they have to delay. I mean, I remember when I was on the jury, Mr. Fitzgibbon was late. It was a Monday morning. I think it was like the second week. Mr. Fitzgibbon, he was one of the defense lawyers, and he'd been to London for the weekend, and he was stuck on a train. So I don't know whether he just thought he could catch the first train back to Preston from London on the Monday morning, and that'd be fine. But the train was delayed. Now, they started the trial because Mr. Fitzgibbon had like a number two, and the number two just stepped in because Fitzgibbon actually didn't need to do anything, and he was only like an hour and a half late, and he literally ran into the courtroom. I bet the judge gave him a bit of a dressing down after, but, you know, if Mr. Fitzgibbon had been stuck on a train and Mr. Fitzgibbon, you know, was needed that morning, then we'd have had to delay, wouldn't we? Just things happen. Things happen when lots of people have to get together. And if someone's late, then, you know, it's unavoidable. Anyhow. Okay, Rosie asked for 5-minute recess. Gull responded, why? Rosie says it would like a few minutes to discuss their options with co-counsel and Richard Allen. So I think Rosie is realising that she's not going to shift. She's not going to budge. She's not going to say, okay, we'll give you another 2 weeks, or we'll tell the jurors that they may have to stay longer. He knew she's not going to budge. So therefore, he's thinking the only option is to delay the trial and plead for longer time. After recess, Rosie states he would like to put on the record that during their recess, officers were with them the entire time and they had no privacy with their client. They're doing it again. They're doing it again. Like, they can't meet with Richard Allen in a confidential way. Anyway, Rosie says the same thing occurred at the March hearing. Defence waives the right to a speedy trial. So they got a conflab. They asked for a 5-minute recess. They had a conflab, and they must have all agreed with Richard Allen that there's two options here. It's either go with the May trial and then she just not budge, and that then allows McClelland to take up, whether he's meaning to or not, take up the entire time, and then the defence has no time to put their case together, like to present anything. Like, Gull is just expecting them not to put on a defence, but they need 15 days. They've anticipated, their side of the, side of the aisle needs 15 days. Well, that's longer than the trial dates she's given them. Anyway, so they waived the rights. It was there. She didn't give them any option, really. Like, it was either that or waive the right. So it's just a Hobson's choice, isn't it? Baldwin informs Gull that they have a motion to disqualify the judge with them and asks if he can approach to provide Gull with a copy. Gull says no. She says she will read it after he e-files it. So it's not come out yet. I did check before I went live, and he's not filed it yet. So there is another motion in the works to disqualify the judge. Now, we know what she's going to say. She's going to say, denied without hearing. That's exactly what she's going to say. Gull sets the jury trial for October 14th through November 15th. So that is a full month. So 2 weeks each. Well, I'm a little bit less than 2 weeks because they'll have jury selection for the first 3 days. But it's almost a month. Okay. Rosie asks if she's also guaranteeing they have 15 days to present their case. Gull says if they cannot try this case in 30 days, then something is wrong. Now, I put on Twitter earlier, there is something wrong with this case, and it's her. The thing wrong with this case is Francis Gull. Correct me if I'm wrong. Rosie jumps up and says, "You don't know anything about this case," respectfully. She doesn't. She seriously doesn't, because she's not read. She's not read the Franks motion. She's not read the memorandum. She's not. Rosie states she never set any pre-trial hearings regarding evidence issues. She's not. She's just denied everything or ignored it. She's either denied it or ignored it. She's not given them the opportunity to present any evidence, because when they have in, written form, she's just denied it. It's clear she's not read it. Rosie also expresses frustrations with communication issues with the state. McClelland says he has no idea how long the state's case will take to present. We have the burden of proof. We have no idea. And he's right. They will have no idea. They can give a rough estimate, but once they're there in the courtroom, anything could happen. Why do they have to be timed? I mean, look, tell the jury it's going to last 8 weeks. And if it doesn't last 8 weeks, well, great. they finish earlier. Why not give it an 8? If she wants to actually set a time limit, why not set the time limit so long that there's absolutely no way that the jury is going to get caught off guard? Why not give it 8 weeks? McClellan promises to be efficient when presenting this case, but he shouldn't have to be. He should be able to present his case for as long as it takes to present his case. And the defense should have as long as it takes to cross-examine his witnesses. And then likewise, when the defense wants to put on a third-party culpability defense, they should have as long as it takes, and the prosecution have as long as it takes to cross-examine those witnesses. It's not rocket science. This is the basic tenets of how courtrooms work in any civilized country the world over. Now, I think this is positive. Gull sets hearing. So this is going to be a 3-day hearing. Now, again, the injustice is going to be in the dark, because I can bet you, I'll bet you my house, that she doesn't allow cameras into this 3-day pre-trial hearing. So it's going to be from the 21st to the 23rd of May. So 3 days to cover the following: motions in limine, multiple motions to suppress and compel, and a motion to rule on admissibility of evidence. So that's coming up in a couple of weeks. McClelland asks if that hearing will also address the outstanding Franks motions. Gull says no, Franks will not be heard at that time. So there's a 4th Franks motion. They've tried 4 times to get her to at least give them the opportunity to present what evidence they've got. And she said no. Every time she's denied it without a hearing. They're trying for a 4th time. And she said no. This 3-day pre-trial hearing where she's going to allow, these things to be discussed, it doesn't include the Franks. McClelland says he will respond to Franks 4 soon and inform the court of his motion to rule on admissibility of evidence. McClelland says he filed the motion, but would like to file the evidence under seal because it's pretty incriminating. Ooh. So whatever this is pertaining is interesting. Gull accepts seals documents from McClelland. Now, I don't have a problem with them sealing documents. I don't have a problem with that. As long as he's not trying to hide anything. Gull reiterates that she will not be emailing any longer because emails end up in pleadings, and she doesn't think that's appropriate. Libretto sat stateside this time, and that's it. So I don't know what that meant, that little throwaway comment at the end there. So William Libretto was in the court, but sat stateside. I don't think it matters behind which table, the audience sits. But anyway, so I thought that was interesting. But I can't account for the accuracy of any of this. It's consistent with what some of the journalists are reporting about, the main issues. But I thought it was interesting. Just to share it. She shouldn't be a judge. No, she shouldn't. I think if she worked at McDonald's, she'd cock it up. So So yeah, he's got a while yet to wait. So I think the next big thing is going to be finding out what happens to him. Like, where's he going to go? Is he going to go back to Wabash, or is he going to stay in Allen County Jail for the foreseeable future? Now, I'm guessing that Rosie and Baldwin will want him to stay in Allen County Jail. But, you know, it's obviously a lot closer to them than going to Wabash. And also, with it being a county jail that is used to housing pre-trial detainees, they'll have a place, surely, unlike Wabash, they'll have a room where the attorney and client can meet when they need to. He looks better than he did. I think he's put on a little bit of weight. He's 147 pounds. He's lost a quarter of his body weight. As I said in my, was it this morning? Yeah, it was this morning. I did a video and I said, you know, if you want to lose weight, then go to Indiana, commit a crime, and you'll get sent to a state prison and you can lose a quarter of your body weight without even trying. He was just over 200 pounds when he was arrested, like his first, you know, mugshot and details. And he's now 147 pounds. So he's lost a quarter of his body weight. His eyes look, I don't know, hollow. He's just aged so much. I mean, it's going to be 2 years. By the time this trial comes, he's going to have been in state custody for 2 years under horrible conditions. Yeah, he looks vacant. Yeah. I mean, in these notes, you know, it says that he seemed less alert today than in March, but did smile a couple of times with his attorneys. Yeah, there were some comments from people who were at the March hearing who said he looked better and he looked, you know, looked like he put on a little bit of weight. He didn't look drugged like he'd looked previously. So I don't know. I don't know. She can't work at McDonald's with an attitude like that. No, she can't. She'd get fired. I don't know many jobs where you could have such a blatant disregard for the basic rules of the job and still keep a job. He still looks medicated. He does. He does. I mean, he probably is medicated. I mean, he suffers from depression, so I'm guessing he has medication for that. I don't know whether he has any other conditions as well. So we'll wait and see where he ends up. I'd prefer him to stay in the county jail, any county jail, than going back to a state prison. It'll be easier for visitors. It'll be easier for his attorneys to get access to him. Baldwin's motion to disqualify the judge. Got to look out for that in the next couple of days. And then the 21st of May, on that three-day hearing. that will just have to rely, I'm quite sure she won't allow cameras, we'll just have to rely on people making notes and posting them. Hopefully, somebody applies for the transcript of today's hearing. Some depression meds can make you gain weight. Yeah, they can. But not in his case. He's lost a quarter of his body weight. Think you have to be framed by the ordinance. That's the key to weight and soul loss. Yeah. Yeah, it'll just lose all hope of ever seeing freedom again. I mean, the thing is, you know, this October trial date, who's to say that she's not going to pull some other ridiculous stunt and it ends up getting delayed again? You know, remember, this was meant to go to trial in January. They were all set to go to trial in January. And then she just decides to disqualify them. Right, you couldn't make this up. I'm so looking forward to this case being done, and it's not going to be done. It's not going to be done. Like, even if this trial happens in October, if Richard Allen's convicted and there's any sniff that there was no fairness to it, it's going to be in appeals. It's going to be in the appeals court for years and years. So anyhow, I'm going to go. The new trial start date coincides with the Carroll County elections. Does it? Does it? That's interesting. At least it won't interfere with Brian Koberger's trial. Well, no, it won't, because Koberger is going to be 2025. Like, it's going to be March 2025 at the earliest. Like, the prosecution want it March 2025, but the defense wants it summer of 2025. Exactly. She disqualified them for accusations that she herself found them not guilty of committing. I know, you can't make it up, can you? Anyhow, I'm going to go. So thank you all for joining me. Don't know if I had any mods in, but anyway, I always thank them. Thank as always to the mods. Don't think I did in donations. If I did, and I've missed one, I am sorry. But it's now 2:43 a.m. So I'm going to go and see if I can get a couple of hours kip. Maybe, maybe not. I still don't feel tired. I don't feel tired at all. Is there any chance of this being a mistrial because of all the shenanigans? I think if either side felt that they'd run out of time and she wasn't able to extend the trial time, then yeah, I would imagine that there'd be a massive grounds for a mistrial. But I don't know what the specific rules on mistrials are in Indiana, but it's just crazy. Absolutely crazy. All right, guys, I'm going to go enjoy the rest of your day or evening or whatever. And I'll see you tomorrow for most of you, but later today for me. Bye, guys.